As a search for the next Chief Justice is underway, we look again at the interview of the outgoing Chief Justice Mogoeng Mogoeng, in which his ethics also came under scrutiny. Mogoeng was grilled about his judicial temperament, ethics, and whether he was a counter-revolutionary judge. Mercedes Besent filed the following report.
I addressed issues that affect the entire judiciary.
Mogoeng also faced criticism for not recusing himself from presiding over a matter in which his wife was one of the parties when he was a judge in Northwest. Commissioners questioned him about his ethical conduct.
There has been an issue about your commitment to ethical behavior. In your statement today, we have explained what the public perception has been, that you were unethical in presiding in a matter and your wife was a litigant.
Yes.
Can you explain in what respect was your wife a litigant?
Mogoeng explained how this happened.
Oh, she was not a litigant. She was a prosecutor in an appeal where a colleague of mine and I were sitting.
So in other words, your wife was performing her duties as the officer of the court.
That is correct, Minister.
And you said before you took a decision to sit in that matter, you sought the counsel of the former Judge President Friedman and other senior judges in Northwest.
He explained in detail, including how he expressed his own reservations at the time.
Indeed, shortly after my appointment, I conferred with them. I said, as you know, my wife is a prosecutor. I don't want to be on the wrong side of ethics. What is the right thing to do? I'm uncomfortable about her appearing before me, particularly when I'm sitting alone. And they told me, as I said, no, there's nothing wrong with that. She can even prosecute while you are sitting alone and so on.
The question about other judges who also presided over matters in which their family members were involved was also brought to the fore.
Over and above that, you were also aware that the former Chief Justice, Arthur Shackleton, had also presided in matters where his own son was counsel. You thought it was 13 times, but in reality 32 times.
At the time, I was only able to pick up 13 cases, but subsequently I realized he actually appeared 32 times before him.
Mogoeng confirmed that he also had knowledge of Chaskelson and other justices of the Supreme Court of Appeal and Constitutional Court who also presided in matters involving their family members.
And also the Deputy President of the Supreme Court of Appeal, Judge Haramse, also presided in a matter twice where his son appeared before him.
Indeed so, Minister.
And Wim Trengrove SC also appeared before his father when he was acting judge.
In the Constitutional Court, indeed so.
And the current sitting Constitutional Court Judge Yakub also presided over a matter where his daughter was appearing.
Indeed, she was junior counsel, but she was appearing.
Moseneke interjected Radebe and interrogated Mogoeng about his comparison with other judges.
Minister, just before you go to the other point, it's also a valid point. I'm sure you go, it's just a different point. Just want to make a little follow-up on the first point. Of course, one's son or daughter does not end up in one's bed.
May I answer?
Certainly. What I'm really saying, let me just make it more explicit. Is there a difference, perhaps this is how I should put it, between a son and a wife in this context? In the sense that, for instance, the law would always say your wife is not competent to be a witness against you because you end up in the same bed, in the same household, but more particularly in the same bedroom usually. Is there any difference there to be made at all? I just wonder.
But Mogoeng defended his position.
As a matter of principle, there is this expression which helps us in this regard. It says, blood is thicker than water. the perception is, because she is your wife, you are likely to be favorably disposed to her than you would to other people. That should apply to your son. The perception is, because he's your son, you may just find yourself tempted to do him a favor so that he looks like a shining star that he really isn't. So the perception in this regard, Chair, must apply to both the wife and the son and the daughter. Otherwise, we're going to engage in a very serious, headache-provoking splitting exercise.
Moseneke was still not convinced about Mogoeng's explanation.
The examples you raise, I read them with interest and concern, but they don't tell me whether or not it was right to be in a case in which your wife was prosecuting. You get my point? In other words, they tell me what other people are doing that might be wrong, but it doesn't tell me, doesn't explain the right and the wrong of the issue that is being raised with you.
Another commissioner interjected.
Let me
Chief Justice, may I come in?
Let me clarify.
May I come in before?
Yes, sir.
Before he answers. Mr. Matlagu here wisely tells me that the son comes from the mother's womb. Thank you.
And
yes.
And you see, this is a principle that is so broad, and maybe we'll understand it when we come from this angle. If I am, say, a cabinet minister, and my wife wins tenders from my department, or my son regularly wins tenders from my department, it is that same principle which move people to think that there is some kind of unfairness and nepotism here that would apply to a situation where my wife appears before me, my son appears before me. Reasonable people are likely to think, hey, he will push his son or his wife's case here. So, my answer was this. I had nothing to refer to. The SCA, as I recall, referred to some decisions of some overseas jurisdictions, precisely because we did not have a case that was spot on. More importantly, I had taken counsel from my more experienced colleagues who are there to guide me and said, good people, please, I don't want to be in trouble. What must I do? And they advised me. And I followed their advice, although I rejected the question of my wife appearing before me when I'm sitting alone. So that's where the question of whether or not I think I did the wrong thing comes in. I took counsel.
Other commissioners entered the debate on judges who preside over matters in which their family members are involved.
I don't think I would like the debate about sons and daughters to be regarded as dead and buried. I think I think we'll be oversimplifying the matter. I thought when you spoke of blood being thicker than water, you drive that logic to that reasoning to a logical conclusion. There are people who love their children more than their wives, certainly, and vice versa. So it is not a matter which can just lightly be pushed away. For my part, I should say this: if an average person were to have a case heard by me, my son argues on behalf of the other person, and I give judgment in favor of the person represented by my son, is it unreasonable for a lay person against whom I've given judgment, which favors my son, is it unreasonable of such a person to worry? It is not unreasonable. So I don't think we should oversimplify things in that manner.
Judge President, I think this is a fairly straightforward matter to anybody who take things as they ordinarily are taken in life. You really can't differentiate the one from the other. You can't.
And on a lighter note, Mogoeng faced another question about allegations that some judges were counter-revolutionary.
Then I want to ask you, are you a counter-revolutionary judge?
I don't understand.
I'll brief you on that. Mr. Mantashe, the Secretary General, said there are counter-revolutionary judges in the Constitutional Court. Are you one?
I think, no, that must be put in a proper perspective. The best person to answer that question is Mr. Mantashe.
Okay, when I see him again, I'll ask him.
Thank you, sir.
On a lighter note, I can confirm he had not yet signed. Congratulations, Minister.
Mogoeng, who's now 60 years old, is left with just over 2 weeks before he bows out as South Africa's top Constitutional Court judge. Mercedes Besent, SABC News, Parliament.